microphone, or did you want to speak from the podium?
Both.
Both? Okay.
If you don't mind. Is that okay?
No, that's fine.
Just in case I start wandering around.
Yeah.
I'll probably stay here. Okay. I have a bad habit of walking off.
Okay, I'll catch you.
That's why it's got a cord.
Right. You have an alarm on it too. I'll go ahead and turn it on also. So just keep it live and just go right there. Stick.
So do you mind if I take a couple of flash photos?
No.
while you're talking?
Would you rather prefer to lecture from the podium, or would you like to have a wireless microphone in case you're wired?
I think wireless
Okay.
is more of a wanderer.
Would you mind attaching this to your wallet?
Yeah.
Do you mind clipping this tie belt?
Yep.
That way?
Mm-hmm.
I'll go ahead and turn it on, and you can clip it to your belt jacket.
Okay. Get this thing on. There we go. Yeah, it's on now.
Hey, hello, everyone. I think we'll just get started now. I'm glad you're all here tonight. My name is Josephine Ko. I'm a second-year law student here, and it's a great pleasure to be able to put on this event. I have a number of people to thank for being able to have Mr. Irons and Mr. Muller here today. Mohammed Dewan, Frank Chow, and Don Blaylock. Thank you very, very much. So on behalf of the Asian Law Students Association, it's my pleasure to present to you Looking Like the Enemy, the Japanese-American internment cases in perspective. And I'll just go over a brief history, very, very brief, so don't worry about that, and then we can get started. In 1942, Japanese Americans constituted just 0.2% of the US population. In 1942, it was also the year that Japan bombed Pearl Harbor, and it was the year that the US entered World War II. And 1942 is also significant because it was the year that President Delano Roosevelt issued Executive Order 9066. And as a result of this executive order, 110,000 Japanese Americans in the western United States were ordered to report to assembly centers. And often these assembly centers were hastily converted fairgrounds and racetracks. For example, you had Puyallup Fairgrounds in Seattle, the Tan Fran racetrack in the San Francisco area, and the Santa Anita racetrack in Los Angeles, all being converted to assembly centers. And later on, these Japanese Americans were sent to internment camps located further in the interior for the duration of the Second World War. And so I'm sure you've heard of these camps like Manzanar, Heart Mountain, and Topaz. In 1942, Asian American immigrants were not allowed to become naturalized US citizens, but even so, 2/3 of the 110,000 Japanese Americans that were sent to the assembly centers and to the relocation centers were US citizens, and about 10,000 more US citizens were born during the period of internment. Fred Korematsu was one of these Japanese Americans. He was an American citizen by birth. He spoke only English. He attended public school in California. And in fact, he was living and working in San Leandro, California, which is near San Francisco, when the war started. And this is also where he had grown up. And when the relocation order came, Mr. Korematsu decided not to obey the order, and he decided to go incognito. He actually had some plastic surgery done, and he actually worked in the shipyards of Oakland building warships for the war effort until he was arrested and later on convicted for disobeying the relocation orders. And it's important to note that Mr. Korematsu was not the only Japanese American who resisted the orders. For example, there was also Gordon Hirabayashi and Min Yasui, two of the other test cases that went before the Supreme Court. In the 1980s, thanks to the efforts of Peter Irons and a number of other lawyers and members of the community, the cases for Korematsu, Hirabayashi, and Yasui were reopened, and their criminal convictions were vacated. And now it's my great pleasure to introduce the two speakers that we have here today. First, we have Eric Muller. Eric Muller is a professor of law at UNC, and I understand there may be some UNC students in the audience, so I'll reserve any sort of UNC comments today. Let's see, Mr. Muller graduated from Yale in 1987, and prior to joining UNC, he was an assistant U.S. attorney for the Criminal Appeals Division in Newark, New Jersey, and he also clerked for U.S. District Court Judge H. Lee Sorokin. And he is also the author of Free to Die for Their Country, the story of the Japanese-American draft resistors of World War II. And our second speaker is Mr. Peter Irons. Peter Irons is currently a professor of political science at the University of California at San Diego. Prior to joining the faculty at UCSD, he taught at Boston College and the University of Massachusetts. And Mr. Irons has a very interesting story about how he ended up at Harvard Law School. And perhaps you can ask him during the reception afterwards. But he basically ended up attending Harvard on a dare. Well, after attending Harvard, Mr. Irons led a very interesting life, and among them helping vacate the criminal convictions of these Japanese Americans. And he is also the author of many books. I'll just name two of them here. One of them is related to the topic that we're talking about today. That book was Justice at War, the story of the Japanese American internment cases. And most recently, he has just published a book called Jim Crow's Children, The Promise of the Brown Decision. So we'll get started with the event. I'll just let you know that the format, first we'll have Professor Muller speak and then Professor Irons, and afterwards we'll have a question and answer session, which will be moderated. And so all of you are free to ask any questions that pop in your minds during the lectures. So Professor Muller, if you're ready, we can start.
Yes, thank you very much. I'm really happy to be here at Duke Law School tonight for a bunch of reasons. Not the least of them is that I really believe very strongly that our two law schools, Duke and UNC, being just a few miles up the road from each other, really ought to do these kinds of joint sorts of things more often with faculty and students getting to know one another. So I'm really happy to be here. I'm really pleased to see some folks from UNC who've come out as well, so that's a good thing. The main reason I'm thrilled to be here, of course, is the topic itself. The topic of looking anew at the internment of Japanese Americans during World War II, so that we can try to get a perspective on that and understand for the controversies and situations we find ourselves in today. But there's an additional reason why I'm thrilled to be here, and that is that the opportunity to serve as the kind of warm-up act for Peter Irons is for a person in my field who does the kind of research and the kind of writing I do. This is a little bit like being sort of the warm-up band for the Beatles or something. I mean, this is Dr. Irons has just done incredible work in this field, and it's really an honor for me to be able to share the podium with him. So, what are we here for? We're here to talk about perspective, getting perspective on the Japanese American internment. Obviously, it's quite important. We all know that it's important in some intuitive way. Certainly since 9/11, we've all been hearing stories about and references to the Japanese American internment. But what I'd like to do tonight is just talk about a couple of aspects of the story of the internment that are perhaps not as well known as the pieces that Peter Irons is going to talk with you about, the cases that made it to the United States Supreme Court. It turns out that there were actually more people than just Fred Korematsu and Min Yasui and Gordon Hirabayashi who resisted in some way the government's program of eviction and incarceration. And the book that I wrote, Free to Die for Their Country, tells the story of several hundred young men who were drafted out of the camps and into the U.S. Army, and who resisted the draft as a way of trying to bring before courts the lawfulness of the government's entire program. One of the things that I think that this story does for us is to enable us to think through, with maybe 60 years worth of hindsight, maybe in a slightly more detached or dispassionate way, an important theme about what it means to be a good American during wartime. Whether good Americanism means compliance with government decisions, or whether it also can include resistance to and protest of, dissent from government decisions. And then a little bit later in my portion of the program, I want to bring this home and actually talk with you about another important question about perspectives, which is the perspective of that we have here in North Carolina. And I'm going to talk for just a few minutes at the end of my half hour about some recent events that, if you read the local papers, you may have noticed, involving some comments from a congressman out in Greensboro by the name of Howard Coble. So that's my plan. What I'd like you to do, just to sort of get yourself in the framework here, is to just do a little imagination exercise. I want you to imagine that you are, rather than being a law student here in 2003, try, if you can, to imagine that you were an American citizen born in this country to Japanese parents, say in the 1920s, so that by the time of Pearl Harbor in 1941, in December of 1941, you have been living more or less the life that any American kid would have been living. Certainly any immigrant kid or child of immigrants. You would have grown up with some awareness of the cultural, religious, linguistic, culinary background that your parents still undoubtedly held very close to them. But you went to, in all likelihood, a school with white kids, with kids of all of the races and ethnicities and religions that were in the particular community. You grew up listening to the same music as everybody else. You drank Coca-Cola. You had your hamburger and your shake. You know, you were essentially an American kid. And then Pearl Harbor happened. And all of a sudden, you went from being an American kid with Japanese parents to what became known in the newspapers as an American-born Jap. All of a sudden, you're, as if by magic, overnight, your essential ethnic identity, at least in the eyes of those around you, transforms and makes you into an alien, even though you are as much a citizen as they are. Maybe your parents, maybe your father was taken away in the days after Pearl Harbor. Perhaps your father, if he was a judo instructor, or if he was active in a Japanese business association, or active maybe in the Buddhist church, let's say, in your community, there's a decent chance that he was carted off to a detainment camp within a few days of Pearl Harbor. And so then you had a couple of months in which you and your mom and your siblings pretty much had to go it alone. Mid-February rolls around, President Roosevelt signs Executive Order 9066, authorizing General DeWitt, the head of the Pacific Defense Command, to basically do whatever he wanted to anybody. But the place that he begins to operate is against Japanese aliens and American citizens of Japanese ancestry, without any distinction between aliens and citizens. First, there's a curfew. First, you're told that you have to stay in your home from dusk to dawn. And if you leave your home during that time, you are subject to arrest. You're told that you may only travel 5 miles from your home without government permission. If you want to travel more than 5 miles from your home, you may not do so unless you first get the government's permission. Your parents' bank accounts undoubtedly have been frozen, so your financial situation is very grim. Then you're served with a notice that, say 10 days or 2 weeks from now, you are going to have to leave your home simply because the government believes that you are suspicious. You're suspicious, notwithstanding your American citizenship, because you are of Japanese parentage. You're given this 2-week period. During those 2 weeks, you have to get rid of everything because you're only going to be allowed to bring with you what you can carry. A couple of suitcases. So if you had real property, you were left in a situation where you had to either get someone to tend it for you, you had to abandon it, or you had to try to make mortgage payments from inside a concentration camp. Not an easy thing to do. If you had any personal property that you had, if it didn't fit in a suitcase, you either had to try to store it or you had to sell it. And your neighbors knew that they had you over a barrel. So you were selling things like cars, bicycles, fixtures, appliances, personal belongings, jewelry. You were selling these things for penny on the dollar. The economic losses are enormous. You're told that you have to report for confinement. You don't know where, you don't know how long. So on that appointed day, you comply, you show up, and you are taken to the local fairgrounds or a racetrack, which has been converted into a camp. Barbed wire, guard towers, searchlights sweeping the camp, guns pointing in at you, and you are assigned to a barrack. Your barrack, if you're lucky, it's actually been constructed as a barrack. If you're not so lucky, you are put with the rest of your family into the stall that had been used for the horses at that racetrack up until just before. And so the stench of horse urine and horse feces is overwhelming. Your entire family unit is placed into a single room. You have no privacy. The walls only, they're buildings with pointed ceilings, but the walls only go up to sort of where the pointed ceiling begins. So the entire barrack is actually open, which means that quarrels, fights, anything that's coming from some other family unit's dwelling is in your dwelling as well. You're eating in huge mess halls. You're having to share one of just a few latrines with thousands of other people. And you spend a very hot summer of 1942 in that camp. Then in the fall of 1942, you are told that you are going to be placed on a train with the windows blinded, and you are going to be shipped off to a more permanent detention camp, so-called relocation center, although everybody at the time called them concentration camps, in incredibly barren, desolate places, primarily in the Mountain West, places like Hart Mountain in Wyoming, near Cody, Wyoming, not too far from Yellowstone, places like Minidoka in south-central Idaho, places like Manzanar, which I'm sure you've all heard of, places like the Granada Relocation Center in Colorado. There were even a couple of camps in Arkansas, which many people don't often know. And you got there, you were delivered there, and you were up against it for a period of several years. Again, barbed wire, guard towers, military patrol around the periphery, and you were stuck there. You were in barracks again, same lack of privacy. Your family unit begins to disintegrate because the kids want to go off and eat in the mess halls with the other kids. They leave their parents behind. What you probably had, which was a fairly parent-focused, authoritarian family structure, begins to dissolve and to disintegrate. Rifts begin to open between you, the younger generation, and your parents' generation. And this drags on from the fall of 1942 through an unbearably cold winter of 1942, with temperatures in Wyoming plummeting well below zero as a high temperature for the day, blowing snow. Then you make it back into the summertime, where the heat is overwhelming, dust storms. That's the summer of 43, the fall of 43, the winter of 1943. And then into the late winter of 1944, January 20th of 1944, you go to your little mail slot or whatever you had where your family received correspondence, and waiting for you in your family's mailbox is an induction notice into the United States Army. You are to go off and fight on the battlefields of Europe for somebody else's freedom. The government chooses the moment when it has stripped you of every benefit of citizenship and chooses that moment to demand that you comply with citizenship's greatest burden. What do you do? What do you do? It's a real conundrum. What do you do? You are an American citizen. You have identified as an American citizen. Yet, you have been egregiously, grossly mistreated for a period of years, as have your parents. You see no end to the mistreatment in sight. Do you suck it up and you comply with your draft notice? Go off and spill blood on a battlefield to prove the loyalty of Japanese Americans, to make the case with American citizens' blood that Japanese Americans are real Americans, which is what your community leaders, many of them, want you to do? Or instead, do you say, this far but no further? You've pushed me far enough, and you've pushed me too far. And do you attempt to use that moment where finally you are not just one of a faceless mass of Japanese Americans, but you are standing face to face, toe to toe with your government, who has sent you an induction notice to you directly? Do you use that moment to try to bring the lawfulness of the government's entire race-based program before a federal district judge, in the hopes that the courts, even if Congress has failed you, the military has failed you, and the president has failed you, that nonetheless the independent judiciary might come to your rescue? Well, most Japanese Americans complied. The overwhelming majority of them complied with their draft orders. A much smaller number, about a year earlier in 1943, had actually volunteered into the service once it was reopened to Japanese Americans out of the camps. But most people sat and waited for the draft, and then when they were drafted, they complied. They went and they got their physicals, and if they passed their physicals, they were inducted. But about 350 young men at the various camps, and there were 10 of them, made the other choice and decided that this far but no further. Those 350 men were then indicted by federal prosecutors throughout the Mountain West and in California. They were carted off out of their internment camps into county jails to await trial. They were tried, sometimes in large groups, sometimes individually, and with a single exception, they were convicted. That is to say, those who did not choose to plead guilty, and were then sentenced by these federal judges to sentences in typically maximum security federal prisons of terms of between 2 and 4 years. And so off they went to places like Leavenworth, Kansas, McNeil Island in the water off of Tacoma, Washington, to serve out their sentences, having been converted from one kind of pariah now to a felon for having resisted the draft. In my book, I talk at some length about the actual trials that the judges offered to Japanese Americans, and I don't have time to summarize that really for you tonight, but suffice it to say that in the main, these were kangaroo courts. These were travesties of federal criminal justice. Lots of stories in the book, but it was not a proud moment for the federal courts, not at all. And it's important to remember, too, that these cases were being tried in the summer and fall of 1944. This was just 10 years before Brown versus Board of Education. I mean, this is just 10 years before the federal courts, not just the Supreme Court, but federal district judges and circuit judges across the country were going to be launched on probably the most ambitious undertaking in the protection of civil rights that courts in this country have ever undertaken. But it was really a travesty. These resistors served their sentences. Most of them were released in 1946 into 1947. President Truman, on Christmas Eve in 1947, issued a pardon and pardoned all of the Japanese American draft resistors of World War II, along with thousands of other people who had resisted the draft. And so in some small way, the government, at least, made something of a peace, or a truce anyway, with the Japanese American draft resistors. But the real tragedy, I think, is a tragedy that lingers to this day, literally to this day, which is, and it relates to this question that I wanted to raise for you about the legacy of the internment and what it means to be a good American. To this day, this issue from 60-some years ago about whether the right thing to do was to comply with the draft or to resist the draft continues to fracture the Japanese-American community. Not just the generation that was in the camps, primarily them, but their children and their grandchildren as well. It was just less than a year ago that after years of rancorous internal debate, the Japanese-American Citizens League, which is the leading Japanese-American civil rights organization, finally voted effectively to recognize the legitimacy of the stand that the resistors took. The wartime Japanese-American leadership was ferociously anti-resistor, ferociously so. They actually collaborated with the FBI and with the War Relocation Authority. The Japanese-American people from within the Japanese-American Citizens League collaborated with the prosecution, serving as kind of undercover informants, trying to get information from the resistors about how they were organized to facilitate their conviction. To this day, the JACL continues to be divided. When the Japanese-American Citizens League a couple of years ago finally voted to recognize the resistors, a number of Japanese-American veterans from World War II got up, ripped off their JACL badges, threw them on the ground, and stormed out of the meeting. The JACL has taken an enormous hit in its membership. It's a struggling organization right now because a significant chunk of its membership is so pissed off at the organization for having simply stated that the position that the resistors took back in 1944 was a respectable patriotic stand. So that, in a way, I think is the real tragedy. The real tragedy is the pressures that wartime places on a minority community to show themselves to be more American than the next guy, to be 110% Americans. That's the pressure that Japanese Americans experienced. It was a pressure that made one of the two models, the old models of American patriotism, which stretches back to the founding of the country, the patriotism of protest, the patriotism of dissent. It made that patriotism unavailable to Japanese Americans because what might be patriotism, what might be protest or dissent in the mouth of a white American was treason, was disloyalty in the mouth of an American citizen who happened to be born of Japanese parents. And that's a place, I think, that we can think about today, not just when we think about the position that Arab Americans or Muslim Americans are in since September 11th. Obviously, the parallels there are overwhelmingly strong. But I think it's also something to think about for those of us who are not Arab American or Muslim American or Japanese American, but who are wrestling with questions of what are the appropriate boundaries, what are one's obligations as a loyal American during a time of crisis, during a time of conflict, during a time when you might not agree with everything your government's doing. How available to us today is that tradition of the patriotism of protest. When John Ashcroft got up in front of the Senate Judiciary Committee back in December of 2001, just a couple of months after the attacks, and said that anybody who was complaining about the government's enforcement policies were effectively traitors, were giving aid and comfort to the enemy, that's scary. That's scary because that suggests that there is an effort in some way to take one model of what it means to be a good citizen and to enforce that model. That's what was done to the Japanese American draft resistors. The government used the criminal laws, they used the federal criminal laws to enforce a particular model of loyalty, a particular image of what it meant to be a good American citizen. And so this is a message, the message of these cases, the legacy of these cases, I think, is one that's useful for us today, regardless of whether we are a member of a minority that looks like the enemy, to use the title of today's talk, or whether we're not. So that's one thing to think about. The other thing that I'll invite you to think about just for a few minutes and then I'll wrap up is an event that, as I say, some of you may have noticed. It got a little bit of press here in North Carolina for, a week or so, and then it dropped out of the news. I think there's going to be a little more news about it, maybe even in tomorrow's paper, and I'll tell you about that. But 4 weeks ago today, Congressman Howard Coble, who represents the congressional district in North Carolina that includes Greensboro and High Point, was on a morning radio program out in Greensboro. Congressman Coble was recently appointed as the chair of the House Judiciary Subcommittee on terrorism and homeland security. So part of his responsibility will be oversight on behalf of the House Judiciary Committee of Tom Ridge's new enormous agency that just came into being over the weekend, the Department of Homeland Security. Obviously, one of the missions of the Department of Homeland Security, or one of their tasks anyway, is to strike a balance between liberty and security during the times that we're living through. Howard Coble was asked by a caller whether he supported the idea of the internment of Arab Americans. And Coble responded this way. He said, well, no, I'm not in favor of the internment of Arab Americans. But, he then volunteered, I do think that the internment of Japanese Americans during World War II was a justified decision. He said, you know, it was scary times for Japanese Americans. They were scared even to be out on the streets because of concerns of violence directed against them. So the internment was really, part of the reason for it was to protect Japanese Americans. It was an effort to protect them. And he added, not only that, but just as today there are undoubtedly some Arab Americans who mean to do the United States harm, there were undoubtedly Japanese Americans who meant to do the United States harm back then too. So this was a decision, FDR's decision is one that I support. This was to many people, myself among them, a very, very disturbing moment. It would be one thing if Congressman Coble were just a congressman. It would be regrettable. But for the person who is currently responsible, has a position of oversight over homeland security and over striking this balance between liberty and security, for that person to be resurrecting this old canard, and that is what it is, this old, long discredited canard, that the internment of Japanese Americans was undertaken for their own protection, is, I think, bordering on outrageous. Congressman Coble, when he was confronted with something of an uproar from his comments, pretty much dug in his heels. He said, look, I didn't mean to hurt anybody's feelings, and I recognize that the internment was a cruel thing. And probably looking back on it today, it looks wrong. But at the time, it was a justified decision. And it was justified because it was, in fact, undertaken to protect Japanese Americans, and I'm not going to apologize for that, unless and until somebody proves me wrong. Well, a number of people undertook to prove him wrong. A number of people, a number of historians and others. I myself faxed Congressman Coble a 4-page single-spaced letter in which I detailed, chapter and verse of what the reasons were for the government's policy of internment, and demonstrated that protecting Japanese Americans had nothing to do with it. Congressman Coble has not responded to any of these criticisms, and this is not, a fit of pique on my part that, a congressman didn't respond to my letter. Calls have been coming in from all over the spectrum. Tom Daschle, Nancy Pelosi, various advocacy groups, not just Japanese American groups, but groups stretching from the Anti-Defamation League to all sorts of groups, calling for Coble to retract his comments and for him to step down as chair of the Subcommittee on Homeland Security. Those calls have thus far been completely unavailing. Congressman Coble hasn't said anything about this for weeks. And his strategy, and I think the leadership in the House, their strategy has been just to put their heads down and wait until it blows over. Just this afternoon, late this afternoon, just before I drove up here, I was alerted that Senator John Edwards, who is, as you know, one of our senators and also running for president, issued the following statement. It is always disappointing when one of our nation's leaders makes divisive, ill-informed remarks like those made by Representative Coble. He was wrong and he ought to apologize. As leaders, elected officials have an obligation not to divide but to bring groups together. Leadership means thinking of America in terms of us, not them. Leadership means being committed every day to making equality a reality. It means learning from the past and making a better future for everyone. Representative Coble failed to lead. Because of that, the Republican Party should seriously reconsider keeping him on as chairman of the House Judiciary Subcommittee on Crime, Terrorism, and Homeland Security. Someone who thinks it was okay for the United States to put innocent Americans behind barbed wire fences in 1942 should not make decisions about how to protect Americans in 2003. I think Senator Edwards is right on with that comment. I'm pleased, really pleased, that maybe a little belatedly, but he eventually got around to it. And this is a story that I think perhaps we've not seen the end of. And it's a story about, really, ultimately, about the meaning of the Japanese-American internment. Often, those of us, I'm sure this is something Peter Irons has heard too, often those of us who write and research in this area are met with skepticism. We are charged with revisionist history, with viewing historical events with the benefit of hindsight, judging historical actors with the benefit of hindsight. It's a very commonly voiced criticism. And we could have an interesting discussion about whether that's in fact what current scholarship on the Japanese-American internment does. But for these purposes, I'll even concede that my work is based in hindsight. And I would say, if we can't even get our hindsight to 2020, if even our hindsight isn't accurate, then what chances do we have of seeing things accurately today? Surely, at a minimum, we should hope that our hindsight will be 2020. And the way we do that is by stating frankly what happened to Japanese Americans during the Second World War in all of its complexity, so that we have at least a chance of not visiting those same sorts of deprivations on other people who look like the enemy in 2003. So thanks very much for listening, and it's my pleasure now to turn things over to Peter Irons.
I want to thank Professor Muller for a fascinating and very insightful introduction to this topic and telling you about what happened during the internment. And before I begin, I want to thank Josephine Coe and all the people who worked with her to put this together, to invite us here, and to make this happen tonight. It's a great pleasure for me to be here, particularly because being in a room like this, a law school classroom, I don't teach law students now, at least full-time, reminds me of an experience in a very similar room, Langdale Hall at Harvard Law School, 25 years ago. It might have been 25 years ago today. It was during my constitutional law class with Professor Lawrence Tribe. And I remember among the 300-odd cases that we discussed in that class, one day I read excerpts in the casebook of Korematsu versus the United States. I had never heard of this case before. I had never heard of the internment of Japanese Americans. And I was a pretty well-educated person. I'd grown up, I'd lived all across the country, Washington State, New York, Massachusetts, Ohio, Delaware, the traveling circuit of military and corporate kids. And I'd never heard of the internment. And to my knowledge, I did not know a single person of Japanese ancestry. That's an indictment of our educational system. Now, in California today, where I live, it's required by state law, part of the state educational standards, that students in the public schools are taught about the internment. But I grew up totally unaware of it. So I read Korematsu, or the short excerpt in the case book, or maybe just the head note. But at any rate, I was shocked. And of course, Professor Tribe, like virtually every law professor who teaches constitutional law, told us that this was a very bad decision. It was bad because the court had relied upon unjustified stereotypes about Japanese Americans and had validated a principle of racial disparity, racial discrimination in the treatment of American citizens that was at odds with our whole background, our whole tradition, the 14th Amendment, the Due Process Clause, Brown versus Board of Education, all of that. And it struck me, how could the Supreme Court have made such a bad decision? Not only in Korematsu, but the year, which was decided in December of 1944, but the year before, 18 months earlier, in Hirabayashi versus the United States, and a companion case called Yasui versus the United States. How could a court that contained such liberal justices, icons of our constitutional history, Hugo Black, William O. Douglas, Frank Murphy, Harlan Fiske Stone, Felix Frankfurter, these are great justices, men who were conscious of what they were doing. How could they have put their names on a decision in Hirabayashi, which was a unanimous decision upholding the curfew applied to Japanese Americans? And so I became interested in what Professor Eugene Rostow of Yale Law School called very quickly after the decision a constitutional disaster. He wrote an article by that title in the Yale Law Journal, a constitutional disaster. How could this have happened? And I became interested in sort of doing an autopsy on the Supreme Court. What led them to make such an egregiously bad decision? And I discovered in the course of research on that issue, I decided to turn it into a book, Justice at War. The title itself sort of deliberately has several meanings. The Justice Department versus the War Department. Justice during wartime. Justice at war with itself. And so I decided to write a book. And as a good historical researcher, I asked the Department of Justice, the Freedom of Information Office, for its case files on Hirabayashi, Yasui, and Korematsu. This was in 1982. At that time, I had no inkling of what might come out of that other than your standard academic, give me tenure kind of book. And, well, I had already done that one, but do another one. And I asked them for the files, and the initial response was, we lost them. We don't know where they are. The only evidence I had that these files existed was a 3x5 card in the National Archives of the case file number, Korematsu versus United States, the Department of Justice case file number. And it was indexed under the Alien Enemy Control Unit. This was a special unit of the Justice Department set up during the war to prosecute Japanese Americans who had resisted. Korematsu, Yasui, and Hirabayashi were not the only ones, but they were the only ones who resisted, who took their cases to the Supreme Court. There were others who pleaded guilty, others who were never apprehended. But this 3x5 card turned out to be literally a gold mine of information, because the Freedom of Information Office called me back a couple of weeks later. I was then in Boston, teaching at Boston College Law School, and they said, we found the files. They were misplaced 40 years ago. They're out in a warehouse in Maryland, and they were indexed under another agency which had long since disappeared, called the Alien Enemy Property Unit. And Professor Muller told you about the Japanese Americans who were forced to dispose of all their property, real and personal property, within usually a week or 10 days. Much of this was turned over to government for safekeeping, and particularly bank accounts. And there was an office to do this. These files had been mistakenly put with those other files. And so they said, well, you can come down to Washington and look at these files. And I went down there, and I told this story to a small group here at lunchtime, but I'll tell it again because it's one of those epiphanies, one of those moments that you never expect to happen, will never happen again, and something comes out of it that is totally unexpected. So I went down to the Calvin Coolidge building, the Department of Commerce, aptly named, and found 3 cardboard boxes covered with dust, wrapped in old twine. They had not been opened in 40 years. It was quite obvious they hadn't been touched. They'd simply been lifted, put in this office. I opened the first file, Korematsu versus United States, and there was a manila folder on the top. And I opened it up, and the very first document on the very top, I was going to go read it to you, but I have it emblazoned in my memory, so I'll tell you from memory, was a memorandum. Now this goes back to hindsight. Those who say that this decision was justified because it was the only alternative, the only option available, forget that there were those who opposed it, those in government positions who fought against it. They lost that fight, but they had the insight and the courage to stand up at the time. One of those was a lawyer named Edward Ennis. Edward Ennis is one of my heroes. He later became the general counsel of the Japanese American Citizens League, was the general counsel of the American Civil Liberties Union for many years, a man of great courage. Ed Ennis was then the director of the Alien Enemy Control Unit. He wrote a memorandum to the Solicitor General of the United States, a man named Charles Fahey, also a very respectable, decent, basically decent person. Later became a judge on the United States Court of Appeals in the District of Columbia. Charles Fahey was the Solicitor General, and he was preparing the Supreme Court brief and argument in Korematsu. And as part of that brief, he was submitting to the Supreme Court a report, an official report from the War Department, report of General John DeWitt, the commander of the Western Defense Command who was in charge of the internment. It's called the Final Report on the Evacuation of Japanese Americans. In this report, General DeWitt said the evacuation, the relocation, the internment was justified because there was evidence that Japanese Americans had committed acts of espionage and sabotage. This was the official justification. President Roosevelt's executive order said, in order to protect the nation, the homeland, against acts of espionage and sabotage, the War Department is authorized to evacuate any and all persons from military zones. And General DeWitt said, we have evidence that acts of espionage and sabotage were being committed. And Solicitor General Fahey was giving that report to the Supreme Court to take judicial notice of its contents. And Edward Ennis wrote a memorandum to Fahey in which he said, we have learned that reports of the FBI, the Office of Naval Intelligence, the Federal Communications Commission, the Army Intelligence Command reveal no evidence whatever that any act of espionage or sabotage has been carried out by any person of Japanese ancestry. There are none. Therefore, the submission to the Supreme Court of an official report which contains intentional falsehoods approximates the suppression of evidence. It is unfair to this racial minority that these lies contained in an official government report go uncorrected. This is the only opportunity this department, the Justice Department, has to correct these falsehoods. Solicitor General Fahey received this memo, he read it, and he ignored it. He ignored it, I think, because of a feeling that the President of the United States during time of war should have the authority to carry out these acts. And the Supreme Court and Solicitor General Fahey stood up before the Supreme Court in arguing the Korematsu case, and he was asked a question by Justice Frank Murphy. We have the report of General DeWitt, which you have submitted to us. Do you stand behind the allegations in that report? And Solicitor General Fahey said, I stand behind every sentence, every line, and every word of that report. That is exactly what he said. And I later found a transcript of the oral argument in Korematsu in which he said that. The Supreme Court accepted his representation that General DeWitt's report was credible. And on the basis of that report and the Solicitor General's vouching for it, they upheld the internment. Now, there's as is always true, a sequel, a second chapter to this. The Supreme Court upheld the internment. Now, as I said, in Hirabayashi, it was a unanimous decision. That was the decision that upheld the curfew. Gordon Hirabayashi, who was a college senior at the University of Washington when the war began, he was an Eagle Scout, graduate of Auburn High School in Washington, senior at the University of Washington. He was also a Quaker, member of the Society of Friends. And he decided, both on religious grounds and constitutional grounds, he'd studied con law as an undergraduate, that this violated his rights. And he decided to resist. He went down to the FBI office in Seattle, turned himself in, said, I'm violating the curfew. And they arrested him, put him in jail, put his parents in jail, brought them from the internment camp to testify in his trial for the sole purpose of showing the jury that they were Japanese, that they spoke English very poorly, and that therefore their son was not a good American. And Gordon later said, I will never forgive the government for putting my parents in jail like that. He was convicted in a trial that lasted about an hour. The only evidence was he was a person of Japanese ancestry. He had admittedly violated the curfew, and he was found guilty and sentenced to prison. Fred Korematsu was a shipyard welder, as Professor Muller told you, in San Leandro, California. He'd volunteered for military service and been turned down because of an ulcer, but he wanted to join the Navy and was turned down. Min Yasui was a lawyer, a graduate of the University of Oregon Law School, and a reserve officer in the U.S. Army. The day after Pearl Harbor, he reported for service at Fort Vancouver in Washington and was turned away on the ground that he was Japanese. And he was, to use a word that has already been used here, so I guess I can use it, he was really pissed off. He came back 8 times to report for service in his uniform and was turned down each time. And he was so pissed off that he went down to the police station in Portland, holding a copy of the curfew order in his hand, a copy of his birth certificate in the other hand, and he said, I'm a person of Japanese ancestry, I'm violating the curfew, lock me up, which they did for 9 months in solitary confinement. And he was convicted. Fred Korematsu went underground, as I think Josephine told you. He had plastic surgery. He wanted to stay with his Caucasian girlfriend. But somebody turned him in. Somebody recognized him. The plastic surgery did not really change his appearance. And he was locked up. And in a few minutes, I'll read to you something Fred said more recently. These were all native-born American citizens. They were all highly patriotic. What was their crime? Their crime was their ancestry. That was their one and only crime. Now, in its decision, in the Hirabayashi case, this is what I find appalling and repugnant. We all know, no, I should not say that. We all should know, and I'm sure we soon will know, about a famous case decided in 1886 called Yickwo versus Hopkins. Anybody ring a bell? Okay, Yickwo versus Hopkins. Fascinating case. What happened in Yickwo? Well, the city of San Francisco passed an ordinance. You couldn't get a license to operate a laundry in a building that was constructed of wood without a permit from the fire marshal. Perfectly good police powers law. Protect the public health and safety. Problem was, there were 310 laundries in San Francisco, 200 owned by persons of Chinese ancestry, the other 110 by Caucasians, most of them for some odd reason French and Belgian. The fire marshal gave permits to every one of the Caucasians, except one, who happened to be the only woman, and turned down all the Chinese. It went up to the Supreme Court, and the Supreme Court unanimously struck down the city ordinance on the ground, as the court said in Yickwo versus Hopkins, to discriminate among persons, not citizens. Most of the Chinese were not, in fact, American citizens. To discriminate against persons on the basis of their race alone violates the Equal Protection Clause of the 14th Amendment. If the government, even on a neutral basis, with an evil eye and an unequal hand, operates so as effectively to deprive any person of rights guaranteed by the Constitution, this violates the principles upon which our country was founded. Yickwo would be the perfect precedent for Hirabayashi. It would also have been the perfect precedent for Plessy versus Ferguson, but that's another story. So, the Supreme Court had before it precedent on which to base an honest decision. And what did the court do? Let me read you a short excerpt of the opinion by Justice Harlan Fiske Stone, the majority, or the unanimous opinion in Hirabayashi, in which he said, "There is support for the view that social, economic, and political conditions which have prevailed since the close of the last century, when the Japanese began to come to this country in substantial numbers, have intensified their solidarity and have, in large measure, prevented their assimilation as an integral part of the white population." That was their crime, that they were not an integral part of the white population. This is a classic example of what I call the genetic theory of loyalty. You inherit it from your ancestors. It's not something you develop on your own. It's ascribed to you on the basis of your race, your ethnicity, your gender, your religion, whatever characteristic is being singled out for invidious treatment. It was a flatly racist argument. So the Supreme Court made two very serious errors in Hirabayashi and Korematsu. They based their opinion first on a flawed theory of loyalty, and secondly upon flawed evidence of disloyalty. Now, going 40 years, flashing forward. The document from Edward Ennis to Solicitor General Fahey, "We are telling lies to the Supreme Court." That's the word he used, lies. Is it not only ethical, but is it lawful for the Solicitor General of the United States or for any attorney to stand before the Supreme Court or any court and deliberately tell falsehoods? And the answer is obviously no. Now, Fahey could have asked Ennis, well, let me see the reports on which you're basing this memo. And in fact, Ennis showed them to him. And he again ignored them. So on the basis of this memorandum and a number of others that I found in the Korematsu and Hirabayashi files, it struck me, maybe we can still do something about this 40 years later. Now, I'm going to tell you something I don't normally tell audiences. Not something that I'm embarrassed to say or ashamed of, something that I'm actually very proud of, really, that I'm a convicted felon. And that's one reason I feel a solidarity with Fred and Gordon and Min. A convicted felon sentenced to initially 10 years in federal prison for violating the Selective Service Act, served 3 years of that sentence. And out of that experience, and this was a response not so much to the war in Vietnam, although that was part of the reason, but even more my experiences in the civil rights movement, being unwilling to fight in the army of a country that still practiced apartheid, which it did at the time. And feeling that the highest form of patriotism, the highest form of loyalty, is to stand up and voice your opinions and not be afraid to do that. And Gordon and Min and Fred were not afraid to do that, but they paid a price. They suffered for that. For 40 years, they were convicted felons. Now, in 1982, I contacted all three of these men. They were all still alive. In fact, Gordon and Fred are still alive in their early 80s. Min Yasui died about 10 years ago. And I asked them, would you be willing to reopen your cases with no guarantee at all that we can succeed on the ground? And this goes back to what I said about my being a convicted felon. I discovered through the Freedom of Information Act, when I was in law school, back in the 1970s, I was a very late law student, that there was a very obscure provision of federal law. Section 28, Title 28, Section 1651A of the Federal Code, providing a remedy called the writ of error coram nobis. Now, we've all heard of the writs, habeas corpus, most importantly. The writ of error coram nobis is a very unusual, it's one of what's called the ancient writs from English common law. And it allows a person who has been convicted of a crime, who has exhausted all of his or her appeals and has served their sentence, to reopen a case on the ground, it's a very narrow ground, that there is evidence which was concealed from the defendant at the time, deliberately withheld by the government, that either offered false evidence to the court or withheld exculpatory evidence. This case, of course, had both of those. The defendant also must still be alive to be a party. So I asked these three men, would you be willing to reopen your cases? And they all said yes. And I put together, and I did not do this all by myself, believe me, put together a fantastic team of about 30 lawyers and law students in San Francisco, Portland, and Seattle, where the cases were originally tried. We put together, and it's in this book, this is a book called Justice Delayed, the record of the Japanese-American internment cases. It's a book of documents, the petition we filed, the government's responses, the transcripts of the hearings, the rulings of the district and courts of appeals in these cases in the 1980s. We put together a 150-page petition in these cases, submitted identical petitions to the district courts in San Francisco, Portland, and Seattle. And we had hearings in these cases. Now, I want to read to you just a couple of things. I'm just getting used to these reading glasses after having cataracts removed, and I forget about them. I want to read to you a little bit of what happened at the hearing in San Francisco in October of 1983. Judge Marilyn Hall Patel, who was then and still is a federal district judge, wonderful person, held the hearing. She scheduled the hearing not in her district court room, which is about this size, but in the ceremonial courtroom of the U.S. Court of Appeals in San Francisco because it could hold 300 or 400 people. And it was jammed. And most of the people in the courtroom were Japanese Americans who had been in the internment camps. And Fred Korematsu and Dale Minami, who was our lead counsel, and I sat at the counsel table. And Dale made the presentation of the evidence in our petition, the grounds for granting a vacation of the conviction. And then Judge Patel said, Mr. Korematsu, Mr. Minami says that you would like to make a statement, would you? And he says, Fred Korematsu, Your Honor, I still remember 40 years ago when I was handcuffed and arrested as a criminal here in San Francisco. As an American citizen, being put through this shame and embarrassment, and all Japanese American citizens who were escorted to concentration camps suffered the same embarrassment. We can never forget this incident as long as we live. The horse stalls that we stayed in were made for horses, not human beings. According to the Supreme Court decision in my case, being an American citizen was not enough. They say you have to look like one. Otherwise, you can't tell the difference between a loyal and a disloyal American. I thought this decision was wrong, and I still feel that way. As long as my record stands in federal court, any American citizen can be held in prison or concentration camps without a trial or a hearing. That is, if they look like the enemy of our country. Therefore, I would like to see the government admit that they were wrong and do something about it so this will never happen again to any American citizen of any race, creed, or color. And at the conclusion of that, and you have to be there. Fred Korematsu is a very humble, unassuming, ordinary American citizen. Belongs to the Elks and the Moose and the Rotary Club. Not a public figure. Just saying what's in his heart and his mind. And at the conclusion of that statement, Judge Patel read her opinion, later published. And she said something in there. I'm going to read you one paragraph of that before I conclude, that I think today has even more relevance than it did 20 years ago. And she said this: Korematsu remains on the pages of our legal and political history. I'm going to back up. Before she said this, at the very end of her opinion, she said that the government's, she was making this ruling because, as she said, there is substantial support in the record that the government deliberately omitted relevant information and provided misleading information before the Supreme Court. The information was critical to the court's determination. Because the information was of the kind, particularly within the government's knowledge, the court was dependent upon the government to provide a full and accurate account. Failure to do so presents the compelling circumstance contemplated by the writ of coram nobis. The judicial process is seriously impaired when the government's law enforcement officers violate their ethical obligations to the court. And then she said, Korematsu remains on the pages of our legal and political history. As a legal precedent, it is now recognized as having very limited application. As historical precedent, it stands as a constant caution that in times of war or declared military necessity, our institutions must be vigilant in protecting constitutional guarantees. It stands as a caution that in times of distress, the shield of military necessity and national security may not be used to protect governmental actions from close scrutiny and accountability. It stands as a caution that in times of international hostility and antagonisms, our institutions, legislative, executive, and judicial, must be prepared to protect all citizens from the petty fears and prejudices that are so easily aroused. Now, if that doesn't have a current relevance, I don't know what does. And I want to conclude just by a very short quotation. In the Korematsu case, there were 3 dissenters. Frank Murphy, Justice Frank Murphy, who is not as well known as he should be, he was only on the court for 7 years, was, in my opinion, one of the great justices, a man of tremendous courage and integrity, far more so than people like Frankfurter and Douglas. Frank Murphy wrote a dissent in the Hirabayashi case, in which he said, the treatment of Japanese Americans bears a melancholy resemblance to the treatment of Jews in Europe. We are creating 2 classes of citizens based solely upon their color and their ancestry. This, in my opinion, goes to the very brink of constitutional power. But he did not issue that as a dissent because Justice Frankfurter persuaded him to withdraw it. He said it would be playing into the hands of our enemies to dissent from that decision during wartime. 18 months later in Korematsu, he says, this decision not only goes to the very brink of constitutional power, it falls into the ugly abyss of racism. I dissent from this legalization of racism. Another dissenting opinion, not quite as passionate, but I think more relevant today, Justice Robert Jackson. Now, Justice Jackson, also not as well known as he should have been, was the author of the majority opinion in Barnett, West Virginia Board of Education versus Barnett, the Jehovah's Witness flag salute case, the second case in 1943, in which the court struck down a law that allowed the expulsion of Jehovah's Witnesses for refusing to salute the American flag during wartime and pledge allegiance to the flag. And Justice Jackson in Barnett said, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy to place them beyond the reach of majorities. Our constitutional rights to life, liberty, and property, to due process of law, to freedom of speech and freedom of religion depend on the outcome of no elections. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what is orthodox in politics, religion, nationalism, or any other matter. Now that, to me, is probably the most profound statement about constitutional rights that's been written in a Supreme Court opinion. And Justice Jackson dissented in the Korematsu case, and he says, this court has validated the principle of racial discrimination in the treatment of Japanese Americans. The principle, he said, lies around like a loaded weapon, ready for the hand of any authority that can create a plausible reason for its use. A loaded weapon. Now, that loaded weapon has been picked up, in my opinion, by the current administration. The notion that loyalty is inherited or genetic. The notion, as the Supreme Court said in Hirabayashi, that there is historical precedent for treating those of one ancestry differently from those of another ancestry during wartime. So there's a choice to be made. I think looking back in retrospect, 60 years to the internment, 20 years to the reopening of these cases, to think about these two choices. Because really it is a choice. Whether, and I can't resist closing without quoting from a Supreme Court opinion in 1866. And then I'm going to stop and open up for questions for me and Professor Muller, comments, feedback from you. Imagine this scenario. An American citizen is suspected of aiding the enemy during wartime, providing comfort and support for the enemy, and is arrested. Tried before a military tribunal and sentenced to death on the basis of secret evidence, denied a lawyer. Does it have a ring of the USA Patriot Act? Sentenced to death by the military tribunal, and files a habeas corpus petition with the Supreme Court. And the Supreme Court rules unanimously that American citizens cannot be tried by military tribunals when the civilian courts are open and operating. That they cannot be denied the right to counsel. They cannot be denied the right to confront their accusers. The Fourth Amendment, the Fifth Amendment, the Sixth Amendment. And the Supreme Court said in Ex parte Milligan, our Constitution is a guide for rulers and the ruled at all times. And it protects within its broad reach all classes of men during time of war and time of peace. There is no more pernicious doctrine ever invented by the wit of man, said the Supreme Court, than that any of its great provisions can be suspended or annulled for any of the great exigencies of government. To do so would lead to despotism and anarchy. At all times, all classes of men, during war and during peace. That, in my mind, is the choice. Does the Constitution protect all classes of men at all times, during time of war and time of peace? Or can we suspend these constitutional guarantees because of a national emergency? We did it in the internment cases, to the lasting shame of the Supreme Court. Will we do it again? Well, that remains to be seen, but at least it's worth thinking about in retrospect, how we make those choices. And in the last analysis, it's up to us. We're the ones who make those choices by our own involvement and our own participation in our government and our society. We don't turn these over to those who have a temporary hold on power, because that power, as the Supreme Court said in Milligan, comes only from the people. So there's a happy ending to the story of Fred and Gordon and Min. They are no longer convicted felons. And Congress acknowledged the injustice of the internment in 1986 by voting reparations, $20,000 for each person who survived the internment, $20,000 as compensation for 3 years in a concentration camp. Not a lot of money, but symbolic, and a national apology from the president. But the wounds of that period last today, as Justice Jackson said. That principle that you can treat people differently on the basis of their race or their ancestry or any other characteristic lies around like a loaded weapon, ready for the hand of any authority with a plausible reason. And I don't like having that weapon aimed at me or anybody else. So thank you very much. I really enjoyed being here, and I'd be very happy, and I know Professor Muller would, to answer any of your questions.
Thank you very much, Professors Muller and Irons. We'll have a question and answer session now, and we're turning on the microphones at the table, so if you could avoid brushing the microphone, that'd be great. And then when you have a question, you don't need to stand up. You can just speak as you're sitting, and the microphone will pick up your voice.
And there's free food and drink afterwards.
Oh, right, and afterwards there is free food and drink.
Most important.
I guess I'll start off the question and answer session. Open up with a broad question. With the events that we see happening today, my question is, do you think that history is repeating itself?
Yes. And I say it not to be flip, because it really requires an extended answer, but is history repeating itself in the sense that those who are making laws now and enforcing those laws, or preparing to enforce them if the great exigency of war happens later this month, which I think it will. I'm afraid it will. But are they willing to utilize the same tactics? And I think, unfortunately, that they are. It's interesting. When the USA Patriot Act was being debated by Congress, the Justice Department submitted a brief to the Senate Judiciary Committee about that act, and had the gall to quote Hirabayashi and Yasui as precedent for that. So I think, in a sense, that at least those in government have not learned the lesson, that they undoubtedly, in my opinion, have contingency plans prepared, as they usually do. Remember, during the Cuban Missile Crisis, 1962, there were plans for rounding up all Americans of Cuban descent in this country and placing them in camps. The Internal Security Act of 1950 gave the government the power, it's since been repealed, but it could be reenacted, to set up camps, internment camps, during time of war or declared national emergency. We are, in fact, still in a period of declared national emergency, which started in 1950 with the Korean War. So, could it happen? I think it could. Will it happen? That remains to be seen. Have those in power learned any lesson from this? I don't think they have.
Pete?
You mentioned that you quoted, you read a quote that it's not the right of any official to declare what is orthodox. And then you also said that that the current administration, in your opinion, has picked up the loaded weapon of judging people based on their descent or creed or whatever. Do you think, I mean, I see two things that have happened recently. One is the registration of the of some individuals of, I believe, Pakistani or Northern Korean descent and some other folks. That's one issue. And then two, the faith-based initiatives. Do you think that there's anything in common there in terms of the government deciding what is orthodox and a dangerous precedent being set in terms of a violation of their authority in that sense?
I hadn't thought of faith-based initiatives in this context before, so maybe I should. I do, however, well, I should temper my remarks. I don't want to sound unduly antagonistic to the present administration, because, in fact, there are legitimate security concerns. My point is that those legitimate security concerns can be dealt with in ways that do not involve mass, that is the attribution of disloyalty to people on the basis of some shared characteristic which has nothing to do with their individual acts. The government has every power under federal law and the Constitution to deal with acts of espionage, sabotage, terrorism, to conduct investigations, to hold people, to charge people under federal law. That law is adequate, in my opinion. But to do so on the basis, for example, this registration, it's not just North Koreans, of whom there are very few, to my knowledge, in this country. The citizens of 23 different countries, almost all of them Muslim countries, are being required to register with INS, or what was INS until last week. Why is that? What is the purpose of that? Well, the government did exactly the same thing before World War II. They conducted registrations and they identified by use of immigration documents all persons of Japanese ancestry, singled them out so that as soon, within a day after the Pearl Harbor attack, they rounded up 2,000 people. Now keep in mind, this was a fairly small and isolated population to begin with. 2,000 people, these were the adult leaders, the adult male leaders, virtually all of them, of the Japanese American community in this country. And they were rounded up without any charges being brought against them, without access to counsel, without access to court review. And that's exactly what is contemplated and authorized by the Homeland Security Enhancement Act of 2003, which is currently before Congress. So yeah, I think there's a very clear parallel.
I'd like to address that question and also the one that we opened with. I think they're related questions. And I think that one of the things that current events are doing for us is they're giving us the opportunity to, in asking the question, is history repeating itself? We are invited then to try to understand what that history was. So only by knowing that can we know whether history is in fact repeating itself. And I think we've heard tonight, both from me and from Peter, and we hear in the media many strong similarities between aspects of the government's response to 9/11, aspects of the government's preparation for war with Iraq, and the reaction to Pearl Harbor and the U.S. involvement in World War II. I do think it's also important, though, to recognize that there are some differences between what happened 60 years ago and what has happened at least in the last 18 months, or however many it's been since September 11th. What do we mean when we ask whether the government is making the same mistakes again? What do we understand the basic mistake of the Japanese-American internment to be? There are a number of different candidates. One of them is the idea that it is impermissible to infer anything about a person's loyalties, about a person's sentiments, about a person's viewpoint from the simple fact of their ancestry and their origin. And so what was wrong with the internment was that the government was taking action on the basis of a racial or ethnicity-based criterion. That's one candidate. I think it's a good one. Another candidate is the essence of what was wrong with the Japanese-American internment, the program of internment, was that it blundered in that it effaced the line between citizens and aliens. Well, if that's what you think the mistake of the internment was, then nothing that's happened so far since 9/11 has really shown much of a specter of recreating that particular mistake. Because while the government has undertaken significant action directed at various groups of aliens, it has thus far taken no action of any programmatic nature, or even, frankly, action of any kind that I'm aware of, against American citizens of Arab ancestry. So that's another. Another candidate that you might look at is, well, what was really wrong with what happened back then? The reason we speak of the internment period as a period of great tragedy is because of not just the inference that was drawn, but the enormous burdens and impositions that the government stacked on top of that very, very fragile inference, that very slim inference. And if that's what you understand the basic mistake of history to be, then, you know, I think there's some room for argument about whether we are now where we were then. Certainly, the government has done nothing on the order of taking 120,000 people and placing them into concentration camps. So, you know, one argument, one view might be, well, no, you know, we're fine. History's not repeating itself. But you've got a load of people down in Guantanamo who are in some sort of legal limbo status. You've got registration programs that are being undertaken just as they were before World War II against aliens from Arab countries. So I think this is sort of a non-answer answer, I guess, to the questions. It's a way of saying that the situation we're in right now provides us with a kind of luxury, which is an opportunity to think through something that maybe we had hoped we might never have to confront, which is this question of really what was the mistake? What were the mistakes of that time? And to what extent is there any reason to think we've learned from them? I guess I'm a little bit more sanguine than Peter may be, that I see in the last 18 months at least wisps of moderation that were not present in the period after December 7th, 1941, that leads me to wonder whether perhaps there has been some kind of socio-legal learning that's happened in the last 60 years through Brown versus Board, through the emboldening, the empowerment of the federal courts, through that process, the civil rights transformations of the 60s, the passage of various civil rights acts, and so on. I'm left wondering whether maybe there are some fire breaks that have appeared in the landscape to prevent this wildfire of racism from spreading. But I certainly agree that it's something that needs to be watched tremendously closely.
Are there any other questions? Yes.
I'm glad that you brought up this distinction between the citizens and aliens. And my question is what the extent is of, I guess, constitutional protection for aliens in this country. Because we do often talk about the Japanese internment cases in terms of racial discourses. So how Japanese Americans and Japanese immigrants were racialized as Japanese and Asian. But I think one of the most important questions that Professor Muller brought up was about what it means to be a loyal American. So in that context, and in today's context, how do we think about what happens when, as you've said, the people who are being registered are not American citizens, but are in fact either, I mean, I guess they're looking mostly at people who are legal sort of immigrants of various kinds, but I'm also thinking about political refugees. I read an article recently about Pakistani refugees who are fleeing to the Canadian border, and they're being either arrested or turned away for various reasons. But another thing that sort of jumped out at me from that article was this sort of insistence that the Pakistani refugees were claiming some sort of loyalty to America. So all the quotes in the article from those Pakistani refugees were along the lines of, you know, I love America, I wish I could stay, but I can't because, you know, I'm being driven out. So in that sort of context, what kind of protections are there for aliens?
Yeah, let me just make a, it's a very good question. Clear up a sort of misconception about the Japanese-American internment. There were two groups of people who were interned. There were what were called enemy aliens, that is, persons of Japanese citizenship. And there were native-born American citizens, mostly their children, who were, of course, citizens under the 14th Amendment. However, the aliens were aliens, the vast, vast majority of them, and I can't really think of any exceptions right now. The aliens were aliens not by their own choice. They were aliens because Congress had passed a law in 1906 specifically stating that persons of Japanese ancestry could not become American citizens, were not eligible for naturalization. These people wanted to be American, and that wasn't repealed until 1954. These people wanted to be American citizens. They had applied for American citizenship and been turned down. There's a fascinating Supreme Court case, I'm sorry I didn't bring it along with me, from 1927 called Ozawa versus United States. In 1923, Ozawa versus United States, O-Z-A-W-A. Man named Takao Ozawa, who was born in Japan, and as a very young man moved to this country, first to Hawaii and then to California. He graduated from Berkeley High School and the University of California at Berkeley. And he applied for U.S. citizenship. And the Supreme Court of the United States, in a very odd decision, said, it is conceded that Mr. Ozawa is qualified for citizenship by character, education, and loyalty. However, Congress has excluded him from citizenship, and this court does not have the power. Congress has the plenary power under the Constitution, Article 1, Section 8, to pass all laws relating to immigration and naturalization. They excluded the Japanese Americans, and therefore Mr. Ozawa and all other persons of Japanese citizenship and descent could not become citizens. And this was then used by the Supreme Court as an argument justifying their internment. A classic case of blaming the victim. Now, to be a little less sanguine than Eric Muller, I don't think most people, like ourselves, had foreseen in the days and months before Pearl Harbor what the government's response would be. We knew, or people then knew at the time, that they were making lists of aliens and registering them and preparing in the event of hostilities to apprehend them and detain them. Everybody knew that. What they didn't know was that they would take the next step against U.S. citizens. How can we know that that step is not going to be taken or is not being contemplated? We do not know. Now, it may not happen, and in fact, I think you made a very important point about firewalls. The civil rights movement, the anti-war movement of the 60s and 70s, the growing consciousness, I don't see it much among federal judges, but at least among people like ourselves, that this kind of treatment on the basis of stereotypes and prejudice is wrong, that legitimate concerns about our national security can be dealt with in ways less intrusive and invasive of our constitutional rights than we did during World War II. But I must say that I never underestimate the power of the government to arrogate power to itself during time of crisis or war. And all you have to do is look at every war that we've been in, the Civil War, World War I, even World War II with the internment, the Vietnam War, and other periods of national emergency, to know that there are plans in existence, contingency plans for virtually every possibility. And those possibilities are not limited. The only thing I think that limits the government now is the anticipation or apprehension of widespread public resistance and outcry. And that's you and me. It's not them.
Let me just say, add to Peter's point in one respect. I mean, there's been a statute on the books since the 1790s that enables the president to take action against, to take various sorts of action against enemy aliens as opposed to neutral aliens during times of hostility. And so, presumably, in the event of a war or hostilities with Iraq, it would be that statute would give the president the authority to take actions against Iraqi aliens that he would not otherwise have as to other aliens. The thing that's worth sort of reflecting on is a couple of the perversities of this, though. One of them is, as Peter Irons just said, Japanese aliens could not naturalize as U.S. citizens. So that meant that in 1941, if you look at three similarly situated individuals, a German alien, an Italian alien, and a Japanese alien, the Japanese alien was the one that we knew could not choose American citizenship, who retained his Japanese citizenship not by choice. The German alien and the Italian alien most likely retained their German or Italian citizenship by choice because naturalization was open to them and they didn't take it. So odd that it would have been the Japanese aliens and not the German and Italian aliens as to whom action was taken. But there's another piece of this too. I didn't know that thing about the Cuban Missile Crisis. That's fascinating. Think about Cuban Americans today. I mean, if the United States were going to war with Cuba, I have to assume that the most active group of people rallying behind the American flag against Fidel Castro would be Cubans in this country. Why? Because they're here for a reason. They don't like Fidel Castro. They're exiles. The same thing would undoubtedly be true of Iraqis in this country at this. They're not here because they're friends of Saddam Hussein. And just a personal note here, my family are German Jewish refugees. They got out of Germany on December 31st, 1938. My grandfather had been in Buchenwald concentration camp for several weeks. They spent a couple of years in Switzerland and got into the United States on April Fool's Day in 1941. They landed on a chicken farm in southern New Jersey, and they were there on December 7th, 1941, December 8th, when the United States entered the war against Germany. They became, on December 8th, 1941, enemy aliens because in the eyes of the U.S. government, they were still Germans. Now, never mind that if they'd stayed in Germany, they would have been killed because they were Jews. They were enemy aliens. Their house was searched by the FBI. They had a pair of binoculars and a radio taken from them. They lived under the 5-mile radius thing that I told you about that applied to Japanese Americans. Were my family loyal to Adolf Hitler and the Third Reich? You better believe they weren't. They were deeply loyal Americans at that point, even though they had not yet been able to obtain their American citizenship. America had saved them. So the perversities here are just extraordinary in the assumptions that get made.
Are there any other questions? Okay. Oh, go ahead.
I'm trying to figure out, or trying to remember what the two questions were that were asked of Japanese Americans. In,
The loyalty questions?
Yes. Do you
Yeah.
recall what they were?
Go ahead. Yeah.
Okay, let me make this brief because we're over our time and I'm thirsty. But, and I also want to thank everybody for coming and being with us tonight. It really was a pleasure. This is a very odd thing. Have you stopped beating your spouse? Kind of question. Japanese Americans were asked, every adult in the camps was given a questionnaire, a loyalty questionnaire in 43, I think. 43. And they were asked a number of questions, 2 questions, 27 and 28. Have you renounced your loyalty to the Japanese emperor? Well, what if you never had any loyalty to the Japanese emperor? You say, yes, I've renounced my loyalty to the Japanese emperor. That implies that you had it. No, I have not renounced my loyalty to the Japanese emperor. Ah, we'll send you to Tule Lake where the really bad people went. Okay. The other question, are you willing to bear arms to support the United States? Well, a lot of people said no, particularly women, because they either weren't willing or didn't feel it was the government's right to ask them to bear arms while they're sitting in a concentration camp. These were the people called the no-nos because they answered no to those 2 questions or refused to answer them entirely. They were sent to a special concentration camp, Tule Lake, California, where there were, in fact, a number, I think maybe 5,000 at the most, of people who had announced their sympathy with Japan. Many of them just out of anger at the way they were being treated. But these are people who, for, I think, very good reasons, you know, it would be like asking your grandparents to answer a questionnaire, have you renounced your loyalty to Adolf Hitler?
Right.
As a condition of being released from a camp. And that to me is you know, is astounding.
Okay, so there's food and drink out in the loggia, so you can ask Professor Irons or Professor Muller more questions out there. Right, thank you everyone for coming.